Good afternoon from Chicago, and thank you all for joining us online. And of course, thank you to everyone who's here. Today, we're very happy to host our second lunch keynote on Rethinking the Burden of Proof in Mergers with Professor Oliver Hart. Before we begin, please note again that we're on the record and live streaming, and we'll post this on the YouTube channel later. The views of Oliver are his own, not of the Stigler Center at the University of Chicago. And we hope that you join us for more upcoming events, so check our website, check ProMarket, and check the Capitalism podcasts. So now let me please briefly introduce Oliver. So Oliver is the Lewis P. and Linda L. Geiser University Professor at Harvard University, where he has taught since 1993. He's a fellow of the Econometric Society, the American Academy of Arts and Sciences, the British Academy, and the American Finance Association, a member of the National Academy of Sciences, and a distinguished fellow of the American Economic Association, as many other places I could mention. He used to be the president of the American Law and Economics Association and the vice president of the American Economic Association, Law and Economics American Economics Association. And finally, he's a 2016 co-recipient of the Nobel Prize in Economics, a small addendum to it. And so without further ado, I pass it over to Oliver. We're delighted to host you. Thank you very much.
Thank you. Thank you. Thank you, Filippo. I hope people can hear me. So Luigi is a big believer in diversity, and I think he felt that at a conference of antitrust experts, it would be important to hear from someone who knew practically nothing about the topic, and so that's my role. I have, of course, learned a lot in the last couple of days. It's been very enlightening, although I have to say I'm still a little confused about the consumer welfare standard. Okay, so here's a diagram you may be familiar with. I thought we would actually see it before me, but I think Sanjukta mentioned it, but here it is, and we don't have to go through it, except you'll recall that A2, so this is from Williamson, 1968, you'll recall that A2 is the cost saving, A1 is the deadweight loss. And so I have this bullet point, which is probably wrong, given what I've heard, but it sounded from what at least one of the judges said yesterday, I can't remember which one, that perhaps although judges don't consider the possible efficiency gain A2, they focus on A1, that the agencies that are bringing actions may have A2 in mind in deciding whether to go ahead. So my talk is about the size of A2. And we've heard quite a bit in the last session. There was quite a bit about the possible efficiency gains from mergers. People have argued that A2 may be pretty small. There's an interesting paper by Rose and Salat, which makes this point. It's an empirical paper. I'm going to propose a theoretical argument about A2 being small. In essence, I'm going to argue that after nearly 90 years of theoretical work on the benefits of integration, we still do not have widely accepted theories of what they are. And this should give us some pause. And again, I think Sanjukta was making some complementary arguments at the previous session. So let me give you a quick tour d'horizon, which may not really be necessary for this audience. I just don't know how much you think about the theory of the firm. Not everybody does. So nearly 90 years ago, Coase argued that firms could avoid some of the transaction costs associated with markets or contracts by replacing bargaining with authority. Williamson and Klein, Crawford and Alchin expanded on this by arguing that bargaining costs are likely to be particularly large when parties make relationship-specific investments and a relationship is transformed. You can have an ex-ante very competitive situation, then we make these investments, and there's much less competition. They may even be bilateral monopoly. Now, you probably don't need an example of a relationship-specific investment, but just in case, a well-known one this was studied by Paul Joskow, is a power plant locating next to a coal mine. It's going to use the coal to burn to make electricity, and it saves on the transportation cost of coal. One way to navigate this fundamental transformation is for the parties to write a long-term contract. Indeed, if they could write a perfect, complete, contingent long-term contract, that would solve the problem. Bargaining costs would be eliminated because everything would be sorted out ex ante. But of course, we know it's impossible to write perfect state contingent contracts. It's simply too hard for the parties to anticipate and incorporate all the contingencies that may occur. And if there was any doubt about this, the pandemic is a good reminder of this. I mean, how many parties had pandemic clauses in their contracts? Not many. So it seems that bargaining costs are not so easy to eliminate via contract, but does integration and the authority it yields provide the solution? It would if workers were automata that could be ordered around at will, didn't care about what they were asked to do, and always did what they were told. But of course, none of these things is true. Workers care about what they are doing. They may not always do what they are told, and they can quit, often at a moment's notice. And so the authority that a boss has over an employee is pretty tenuous. So this is a point that was made a long time ago by Elshon and Dempsey. So the whole idea of Cosian authority, people refer to it, but what does it really mean if the employee can quit? I think it's more helpful to think of integration transforming an incomplete contract between two firms into one between a firm and its employees. And that incomplete contract may be just as challenging to navigate. Now, in my own work on this topic with Grossman and Moore, I've suggested that what changes when firm A buys firm B is not that firm A now has authority over firm B's employees, but rather that firm A acquires residual control rights over firm B's non-human assets. According to that line of work, possessing residual control rights protects a party against hold-up when an incomplete contract is renegotiated, because I have more outside options if I have residual control rights. And that's going to encourage me to make non-contractable relationship-specific investments. So that's what that theory is all about. But a problem with that, so it does suggest benefits of integration and also costs of integration. But a problem with this view is that most of the relationship-specific investments that one can think of seem to be contractable. They could be specified in the ex ante contract. Take the example of the power plant locating next to the coal mine. That seems something that we could contract on. The power plant can make the investment. The coal mine can compensate the power plant for making the investment. At this point, so this is what I think is the theory to date, emphasizing either authority, which it's not really clear how much authority you gain over employees, or integration avoiding hold-up problems and stimulating relationship-specific investments. Well, you could deal with those contractually. So I think the theory here is not giving us a clear explanation of what the benefits of integration are. And I think at this point it's worth remarking the most famous case in this literature, the boundaries of the firm literature, is this case where General Motors acquired Fisher Body. General Motors had a contract with Fisher Body to supply car bodies, but then in 1926 GM acquired Fisher Body. And people don't still, there's disagreement about why this happened, with Klein, Benjamin Klein arguing it was because Fisher Body had held up General Motors, and General Motors didn't want that to happen again. Coe's pointing out that actually General Motors already had control over Fisher Body, and the reason they acquired Fisher Body was because they wanted the Fisher brothers, of whom there were many, I can't remember, 7, I think. They wanted them to be on the GM team. So, no agreement about that. And, you know, that's nearly 100 years ago. So, okay, all this to me means that there's a bit of quite a big question mark about the benefits of integration. At the same time that people were trying to figure out these benefits, another important development was occurring, I would like to argue, which is that good contracts were and are becoming easier to write. And let me highlight two reasons for this. One is technological. Computer technology has made it easier for one party to specify what it wants from another party and also to monitor what the other party is doing. A very nice example of this is described in a paper by Baker and Hubbard on trucking. So before the 1980s, long-distance truckers often owned the trucks that they operated, and the most likely explanation for this was that this ownership provided an incentive for the trucker to look after the truck, specifically in terms of speed. So a problem could be that a trucker would drive very fast, have a break, a long break, then drive very fast again. That wasn't good for the truck. If they owned the truck, they weren't going to abuse the truck in that way. But then in the 1980s, a new technology became available whereby a trucker's driving behavior could be monitored, sort of a spy in the cab. The result was, this is what Baker and Hubbard show, that ownership of the trucks shifted to the trucking companies away from the drivers, because the trucking companies could write contracts with the drivers saying, you know, you have to drive at a certain speed and we're going to monitor you and see whether you do it. Whenever you talk about technology in this area, people often bring up blockchain. Something I, you know, like antitrust, I know almost nothing about it. I've never been able to really understand it. But to the extent that I do not think it's going to be useful to improve long-term contractual relationships. So that's a bit of an aside, but I wanted to mention that. Let me turn to a second development that has nothing to do with technology. A long time ago, Macaulay and McNeill argued that contracts alone cannot ensure a successful long-term business relationship. Norms, trust, and the development of social capital also play central roles. And related ideas have been explored by Lisa Bernstein and, of course, in the repeated games literature. And this has led to the notion of relational contracting. In simple terms, the idea is that the parties can do better by combining a contract with the building of a relationship. I've worked recently on this approach together with two practitioners, David Friedlinger, a lawyer, and Kate Vitasek, an expert in supply chain management. We suggest that parties can mitigate contractual incompleteness by agreeing in advance to guiding principles they will apply when unanticipated events arise. So two of the leading guiding principles are equity and loyalty. Basically, the parties recognize when they enter the relationship that stuff's going to happen that they can't anticipate. They can't put it in the contract. The pandemic would be an example, but of course there are many other examples. War in Ukraine. So they recognize that instead of hiring lawyers to put as much into the contract as they can think of, it's never going to work because there's always going to be stuff left out. Instead, what the parties do is they agree to these principles they will apply to complete an incomplete contract. And these principles, loyalty and equity, as the name suggests, involve each party agreeing to consider the payoff of the other party as well as your own payoff. In agreeing to these, it's not just a matter of writing them down. We have to have lengthy discussions about them, and the approach in practice goes under the name of vested or formal relational contracting. It also involves the parties discussing what they're trying to achieve out of the relationship. So presumably, it's actually something that's very close to the way economists think about it. There's some surplus to be divided, and we're actually going to figure out, how to maximize that and divide it in a reasonable manner. And the only reason I stress this is because this is not the typical lawyer approach, which is often seems to be to treat the whole thing as a zero-sum game. The more I can get from my client, the better, and the less the other person will get, and that's all great. Well, this is looking at it from a rather different point of view. So, okay, what's the takeaway from this? What's the message I want you to hear from this? It is that I think contracts seem an increasingly viable alternative to mergers, including horizontal ones, to achieve any efficiencies. So let me give you an example. If I'd listened to the conference before doing the slides, I would have chosen a different example. I would have chosen hospitals, right? Instead, I'm afraid it's banks. But it could be hospitals sharing an MRI machine as opposed to what I'm going to say. The principles are the same. So consider two banks that have branches in every community. This may duplicate space and personnel. One facility could serve both banks. So, something you sometimes hear is, okay, we're going to merge in order to take advantage of these cost savings. But the point is the cost savings could also be achieved if the banks agree that a single facility will provide services to each of them. So the facility could be jointly owned by the two banks or by a third party with whom the banks have a long-term contract, maybe even a relational contract. And this, again, this could apply to the MRI machine as opposed to this facility. And technology can also help. Maybe all they really need is an ATM, which they can both access. So that would be an example of how technology could also solve this problem. Okay, in light of the above, here's my tentative suggestion, and this is the title of the talk. Given that contracts can achieve so much, might it be good to reverse the burden of proof for firms that want to merge, at least the ones with a significant market share? Such firms would have to make the case that they're going to be talking about efficiencies. They would have to explain why they cannot achieve those efficiencies in some other way, including by contract. In other words, they would have to convince the antitrust authorities that A2, if you remember back to the Williamson diagram, A2 was the sort of good stuff. A2 merger is significantly bigger than A2 via contract. Now, I should acknowledge that contractual solutions are not the solution to everything. They can also raise some antitrust concerns. I think that those should be easier to monitor because at least the contracts are visible, or they could be certainly made visible to the antitrust authorities. So I think that might make things easier. So one side benefit from reversing the burden of truth is that we would learn a lot. At the very least, we'd learn a lot. And people like me who work on this, we might find out whether there are benefits of integration after all. So I think it would be a good research experience. That's it. Thank you.
Oliver, as usual, you're way too modest because actually theory of the firm and antitrust are intrinsically related. I was trying to find the exact title of the first book by Oliver Williamson. I think it's Market and Hierarchies, but underneath as something about what does this mean for antitrust. So the theory of the firm, the boundaries of the firm and antitrust are intrinsically related, and you dedicated your life to theory of the firm, so I think that you know a lot about antitrust, even if maybe you don't know the legal aspects of it. But to this point, I find this idea at the same time super simple but super revolutionary, because correct me if I'm wrong, but what I understand is basically you see two firms that merge, and if these are two teeny tiny firms, we don't care, but if they're pretty large, we say the burden of the proof is on you to show what you can do by merging that you cannot do with individual contracts, which is not anti-competitive. So, of course, we know that by merging you can fix prices, but that's the reason why we don't want them to merge. We are open to them merging for other reasons other than prices, but now the burden of the proof is on them. And having worked so much in theory of the firm, what are the chances that they come up with an explanation?
Yeah, I have no idea. I mean, it does seem often that what they say is pretty vague about these, these are synergies, Sounds good. What is it really? I also think, I mean, maybe the only novelty in what I have said, if there's any, would be, I mean, people have always, I think, asked whether you could achieve the efficiencies in some other way, but often they were thinking about it internally as opposed to contract. I'm not sure contract has been that prominent in the thinking. This is, of course, people know about it, but do they think about that seriously as an alternative mechanism?
But you threw it out there almost like a joke at the end, but I think actually there is a lot of wisdom in what you say at the end by saying we're going to learn a lot because all the economists will be working and trying to rationalize what you can do with one or the other. So there will be a new literature exploding, and all, of course, we'll be citing you. So I think that's a big thing, no?
Yeah, it may create jobs for economists. I understand that, it's like conflict of interest there, but...
One last question, then I open the floor because I'm sure a lot of people are eager to ask you a question. We heard a lot yesterday about common ownership. And this is another challenge because take the limit in which two firms have the exactly same three shareholders. We're not there yet, but we're not that far off yet. What are the additional benefits that they get by merging? Because even using your model of property, the property is in the same hands. So what difference does it make to have two merged firms or two firms with the exact same three large shareholders?
Oh, that's a very good question. You didn't tell me you were going to ask that question. I haven't had time to prepare. Okay. The extreme case, you would say, suppose those shareholders really ran the firms, and so they're separate firms, but they have the same shareholders. Then you could imagine that the firms are already maximizing the sum of profits. In which case, the only difference, I guess, if you had a merger, is that instead of having two people making decisions, it would almost be like joint ownership, joint management or joint control, which, sometimes we know people argue and they disagree, and so maybe sometimes it's better to have one person making the decisions, which the merger might achieve. At the same time, I hear what people like Martin Schmalz are saying. I'm still not sure that I fully believe it. In practice, in other words, you can run the regressions, which he does, and that's nice and important, but I would like to hear the stories of people doing this. I'll just throw I read a column, something about Burt Malkiel in the Wall Street Journal, because of some anniversary of his Efficient Markets book, and I think he was asked about this common ownership stuff, and he's on the board of Vanguard, I think, and he said, I've just never seen anything like that. Now, in contrast, when he was asked about environmental things and shareholder pressure there, he said, oh yeah, that's good for us, isn't it? Because we work on that. That resonated with him as something that was really going on. Now, he may be biased and so on, but I would like to see the smoking gun there.
But would be another argument against allowing mergers, because you already achieve most of what you can achieve in this way. So you have to prove that you need
but
more.
Then you would need to perhaps get rid of all these interlocking shareholders. If that was really going on, that would be serious.
Okay. Questions? Yes, Steve.
This is a little different from A little off topic, but I think it would be interesting for this group. In terms of your basic model, would it make any difference whether the workers own the firm or whether the shareholders own the firm? How do things change when it's a worker-owned firm hiring the managers than the managers owning the firm and hiring the workers, or the stockholders owning the firm and hiring both the managers and the workers? So in light of the discussion we had in the last panel, that might be an interesting issue to address.
But that's not about mergers, right?
No, it's not about mergers. It's about your other work.
Yeah.
And it's a more basic issue.
Yes, well, I mean, we do have some work and managed firms out there. They don't seem to be terribly dominant. I mean, there's some notable examples, but if you think of the biggest companies, the most powerful companies, they're not. I mean, and I think there's I basically think people should be able to set companies any way they like. And presumably the reason that they typically allocate votes to shareholders as opposed to workers is because they need to raise finance. I mean, I think that's, in spite of, I mean, Henry Hansman has a very interesting book on this, but he rather de-emphasizes that, but I've never understood that. I mean, if you want to, raising equity capital is a very efficient way of raising finance, and of course we know that shareholders don't have, what protection do they have? They don't have contracts with the firm. I mean, basically, as a shareholder, you get a dividend if the firm feels like paying you a dividend. So you get something else instead, which are votes. So I think there's a reason we see most firms set up with shareholders having votes rather than workers, but not sure that's the answer to your question. But
I guess to follow up, to make it more precise, the workers seem to be lower in the hierarchy. They're not the ones that are controlling, say, relative to the executives, rather than thinking about it as the workers hire the executives. And that I think is a puzzle that a number of people have been thinking about. Why doesn't the baker hire the CEO rather than the CEO hire the baker?
well, I think of it more as a contract. I'm not sure I find that such a useful distinction because, I hire you or you hire me. It's basically we are in a contractual relationship with each other. It's not clear that one of us is superior to the other. I mean, it may look that way, and I'm sure non-economists definitely think it is that way, but economists tend to think of it as just a contract. We're on the same level. Now, I think the question is who has the residual control rights? And actually, it turns out it'll be neither of us probably. It'll be the shareholders who elect the board, who chooses you as the CEO, and then you contract with me.
Okay, we're going a little bit off the topic. Tommaso.
Yeah, I'm Tommaso, yes. So thank you very much. I love your idea, and in fact, in the next panel, I would have said the same, so I don't have to participate to the next panel.
I'm glad I went
That's great.
first.
No, I will take questions. That's fantastic. I just wanted to give you an example. You mentioned ATM in the banking sector, but perhaps another example you may want to think about is in mobile phones, or cellular telephony, as I think you call it here. There are many mergers constantly. These companies, anytime there is a new generation of technology, 1G, 2G, 3G, 4G, 5G, they say technology is different. We have to do massive investments. We need to consolidate, and because that's going to bring efficiencies. The argument is always the same. We know for some reason, empirically, these mergers, 5 to 4 is kind of okay, but really the threshold is 4 to 3. 4 to 3 are terrible for consumers. Prices always go up in a 4 to 3 merger. Unfortunately, you allowed these kind of mergers to happen in the United States, and prices, surprise, surprise, are higher than anywhere else in the world, and so your bills are kind of expensive. In Europe, though, we took, at face value, the arguments we need to merge for efficiencies. The 4 to 3 said, what kind of efficiencies? We're going to do network sharing. It's called network sharing. So in some remote areas, instead of having duplication of investment in cell, we're going to share them. And then the enforcers in Europe said, okay, if that's what you want, do network sharing. Why the merger? So we have not allowed those mergers. We allowed a contractual arrangement about network sharing. Having a look at those contracts as well, because you don't want those contracts to become anti-competitive. And we preserve the efficiency argument that the parties were bringing, still with some competitive pressure on the prices. And by and large, coverage in Europe is as good as the United States, and prices are half of the United States. So this is just another example of what you had in mind.
Tommaso, you did not allow, but a German telephone company did merge from 4 to 3.
I wasn't there.
Because Angela Merkel made pressure. Speaking of political influence of antitrust, and it's just there are rules for everybody, and then there are the rules for the Germans that are different.
So I was just interested in how your proposed criteria would interact with Section 1 of the Sherman Act. So if, yes, I could come up with an agreement, but that agreement would fall afoul of Section 1, is your view that you'd have to prove that you couldn't do it with an agreement that didn't fall afoul of Section 1, or would you concede that just because of the nature of contracting, there are circumstances under which the only way I could do it by contract would be a contract that would be questionable under Section 1. So in a weird way, it's that fact that makes the merger actually the right way to do it? Or is it just clear that what you need to show is that there is an agreement that clearly does not violate Section 1 before you would allow the merger?
Okay, my ignorance. So Section 1, is that about price fixing?
No, Section 1 is just about any agreement. So in the Sherman Act there are two provisions. One violates agreements that restrain, that hurt competition, and the other one is monopolization. That's Section 2. And then Clayton 7 is the one that deals with M&A. So okay. The criteria, again, depending on what the precedent are, they're not exactly congruent.
Well, I would say that so I'm not in favor of agreements that lead to monopolization, anti-competitive agreements. I think one of the advantages of contracts is the authorities can look at them and decide, So I think the question would be, can you come up with a contract which is not anti-competitive that achieves the efficiencies? At the same time, and if you can't do that, that suggests the merger is also about monopolization. So I would think in that case, you certainly wouldn't approve the merger either.
In a sense, your very question, when you said, it's easier to do it with a merger, you are recognizing that many mergers are happening precisely to go foul of anti-competitive rules, or pro-competitive rules. So I think that, Matt.
So I'm thinking about a particular merger, which was the AT&T Time Warner merger in 2017. That was a fairly significant, it was a big merger, and it was something of a disaster. Like there was potentially an attempt at monopolization or not. The judge in the case didn't agree, but the merger essentially was unwound a few years later because it was it didn't work out. And the goal was, well, AT&T has this distribution network through largely mobile phones, and Time Warner has all this content. What if we put the two together? That will be very exciting, and they can compete with Google and Facebook and online platforms, and it didn't work out from a logistical perspective. And I wonder if you think that being forced to do the disciplinary act of writing a contract, saying here's how we're going to benefit, Time Warner and AT&T, you have distribution network, we have content, might have mitigated that immense waste from that merger. And if writ more broadly, you do see immense waste in the form of mergers, and that focusing on doing things through contract might be a way of mitigating this kind of mess.
Yeah, I like that. I would agree with that. I also think, one of the reasons, this came up at the previous panel, that who is the merger benefiting? Maybe only the people at the top, and maybe they're doing it, and it could be not for monetary reasons. They could be empire building. I think that's one of the reasons that, there's a lot of evidence that these mergers often don't yield much or negative. And I think, so empire building mergers are less, if you're doing it by contract, you're not empire building. So that might also be good.
There's one party that always benefit are the investment bankers. I remember many years ago, I was at a meeting of investment bankers with some students, etc. And I said, why don't we get a contra pay on the announcement effect of a merger? You get a fee that is positive and a function of the announcement effect of a merger. The investment bankers were not happy with this. Eric.
There are actually a lot of cases where courts reject mergers because the parties are unable to show that the efficiencies are merger specific. It's the term used. And in fact, they can, the court will hold you can obtain these efficiencies through a contract. But the cases are hard to understand because the courts are never very clear about the test that they're using for distinguishing between a merger, an efficiency that can be obtained through contract versus only through a merger. And one senses it has something to do with economies of scale, but you could obtain economies of scale through a contract, so that can't be it. And I thought what you were going to do is use your earlier work to propose a test, because your earlier work provides, does provide a model for explaining the conditions under which firms would more efficiently merge versus enter into a contract. And I wonder whether you could, maybe I missed it, but I thought that where you were going to go would be a test would be very useful, so that a court could just, if it could be simplified, could just take the party's argument about the efficiencies and then rule whether the defendants make a plausible argument that they can obtain these efficiencies only through a merger. So is there something using, your Grossman-Hart model? Could you propose a test for merger-specific efficiencies?
Well, I think what I'm suggesting, Eric, is very different from what, you're saying that they need to convince a court or whoever that the efficiencies cannot be achieved by contract, right? The only thing I guess part of this talk is saying that I'm not as convinced by the earlier work, including my own, as having really identified what these efficiencies are. So I gave you the example. Relationship-specific investments. The big ones are contractable, I think. We're left with sort of rather vague, non-contractable things. I don't know whether these are first-order importance anymore. I don't know anymore. So, I don't know whether that's the answer. It's, yes, I'm trashing myself to some unquestionably, but also those who came before me.
Cross out. I'm tempted to call on Carl. Can I do that, Luigi?
Yes, please.
Thank you. I think following up, I'd love to hear, and I suspect I'm not alone, if you could say a little more, Oliver. You said now the big investments are contractable. And could you say more about why you think that's true? And maybe I'll just give another example that I like AT&T Time Warner just fine, Matt, but let's go with T-Mobile, Sprint. So that's your 4-3 merger in mobile telephony. So they had this same, we're building out 5G and we're going to be much more efficient by sharing towers. And let's tell a little version of the story where they say, well, it's going to take place over the next 5 years and we're going to consolidate our networks. And we can't write down a contract right now about what that's all going to look like. But we'll have to work it out over time. It depends on how technology changes. So how would you tell whether that was contractable or not, whether that claimed efficiency should be counted as only achievable through a merger? And share spectrum, thank you, Steve. Share spectrum as well.
Sorry, what?
They were also building towers and sharing spectrum rather than each using it for their own operations.
Is building towers not contractable? I mean, I think about, so the co-authors that I've worked with, the practitioners in recent times, so they describe outsourcing contracts, which are complicated. I outsource my software or something like that, and IT. I outsource my IT. There may be many investments involved in that. The parties have to make investments. They talk about what they're going to do, who's going to pay for what. It doesn't seem to be impossible.
Is it important that they be able to sign the contract at the same time that they would do the merger, or is you saying contractable, we'll work out a series of contracts over a number of years, and that's a good alternative to a merger? Is that what you have in mind, a series of contracts over time?
No, not a series, a long-term contract.
But there are lots of uncertainties then.
There's a lot of so then the question is...
contingencies and so forth.
Yes, absolutely. Coming back to, well, I don't want to... I don't want to say that this approach that my co-authors and I have worked on is the solution to everything, but you might want to look at it. There's if you go to my website, you'll see the paper. And
that's the answer to everything, I know.
Using these guiding principles to resolve disagreement seems to work pretty well. This is what these practitioners have found. So I think I'm talking about a relational contract. Yes, we know that stuff is, of course we can't contract on everything. That's also true inside the firm. It's not as if, this comes back to my bullet point, maybe it went a little fast, about, when you put in a new technology, this can, some of the workers who are used to working with the old technology can be quite upset about that. I mean, that's a thing, that's a real thing. That's, again, an incomplete contract. We have contracts with workers. They acquire skills, then we change direction. Or the example that was given, Dennis was talking about, some implicit contract with workers and then is breached by the new boss. So these are issues also inside the firm. I don't think that doing it inside the firm solves all these problems. So maybe the best way to deal with both inside the firm contractual incompleteness and outside the firm contractual incompleteness is to have some guiding principles about how you're going to complete the contract ex post. I don't see a huge difference between them. One is clearly superior to the other.
At the cost of boring everybody, this is actually a topic in which I know something because I was on the board of Telecom Italia, and at some point they actually decided to sell the towers outside. And so there was the reason was stupid because they were thinking that they will save on the cost of capital, but let's keep that aside. But there was an interesting discussion about whether this was a convenient or not convenient thing to do. So on the one hand, if I want to be on the other side, I said, at the end of the day, they did it. So it is possible to sell the towers. And so if it is possible to sell the towers, a fortiori it's possible to write a long-term contract to manage the tower together. They sell to a third party. Okay. Some people inside the board were saying, actually, the risk of selling the towers is what happened when a new technology come about that changes, for example, how much space you need in the tower. And then you have to renegotiate. And I guess that your answer is you have an equity principle, you negotiate in fairness. But I see that in that situation, there is a tension. So that's the part that makes it challenging.
There is a tension, and the question is, how can we find ways to get over the tension? And I mean, just, the example of Chrysler and Daimler came up earlier. I mean, I think that was an example of a cultural clash. The different groups had different ways of doing things. And I mean, there are many examples of mergers which fail because the corporate cultures are not the same. That's an example. I just mention that because it's an example of how problems arise inside firms. Again, it's not as if you can just order everybody around and get what you want.
Yes.
I think this is interesting, but I wonder if by suggesting placing more emphasis on the ability of firms to identify efficiencies that might justify a merger, if you would expand the categories of efficiencies that the agencies should consider. You focused on efficiencies and whether they can be contracted for or not. One area of efficiencies that I've seen in practice on both sides, in government and outside government, is an effort to move the assets from weak management to stronger management, entrepreneurial management. And I'll give you an example. Near the end of the Trump administration, the FTC blocked 2 mergers involving shaving products. Large firm wanted to buy, Harry's. And one of the arguments the parties made was, the folks who started Harry's were just superior managers to the folks running Edgewell. And the agency almost uniformly discounts those arguments. It's sort of easy to say Edgewell could just hire the better management. But often that entrepreneurial manager does not want to leave the assets. So if you're going to expand the importance of efficiencies, would you expand the category of efficiencies, and would you, in some sense, lower the threshold for the agencies accepting those types of efficiencies that cannot be easily contracted for?
Yeah, that's an interesting example. Actually, I think it ties in with the empirical work that Chad did with Hortax and Atterley. This paper, which was actually quite a challenge to people working on the theory of the firm, boundaries of the firm, because what they found was that companies that buy other companies, they don't typically then buy the product from them. So they looked at concrete. Well, what an example would be concrete companies that buy cement companies, right? I know cement is used to make concrete. Is that right?
Yeah, I think so.
I'm never quite sure I got it the right way around. But so you would think that, they're doing this because they want, to be confident about their input. They're going to buy cement from the company they just bought. Turns out, no, they don't. They continue to buy cement from other companies. So why on earth are they doing it? Chad et al. Argue, at least in my interpretation, well, I think they say this, is that if you're in the concrete business, you may also know how to run cement companies. You may feel, this company's not being very well run, and I'm going to run it better. I don't need their input. And I agree that in cases like that, a contractual solution is probably not going to work. Why do I think that? If you push me, I would say it's probably the case that egos are involved. So that if I bought if instead of buying your cement company, I said to you, you know what, I think I know a way to run your company better. I just need a profit share, and I'm going to make suggestions to you. And you'll see how brilliant they are, and you'll implement them, and we'll both win. I suspect that won't work because you will actually reject my suggestions because, you have your own ideas, and you're not going. It's just it's an ego thing, I think, and therefore I actually need control. I don't want to just feed suggestions to you. I want to be able to implement my efficiency-enhancing suggestions. So there's long answer. I do think in cases like that, control is important. So you are asking what happens if. I mean, a lot of those cases, there probably wouldn't be antitrust concerns.
Well, there are some, right? I mean, what I'm basically asking, if you're going to place more emphasis on efficiencies, should the agencies be more accepting of efficiencies that are less,
that
less
kind of
hard?
Efficiency,
I mean, this is, I think of this as, I mean, Tim Yaris gave a speech, 20 years ago. New institutional economics, transactions cost economics, sort of thinking about some of these questions in that way. And that's, a number of the people you've referenced yourself think in that way. And this is not a criticism, the staff at the agencies just don't have a good way to get comfortable, that individual managers are not, homogeneous goods, basically. And they, they become, they're dismissive of those arguments, and,
I think one would have to take that kind of argument more seriously. I think another question, though, would be whether somebody else could, we have a takeover market, so another way to replace inefficient management is not to have someone in the same industry buy the company, but to have someone make an outsider make a takeover bid. So I think that would have to be considered. But yes,
Eleanor.
I would consider that.
Thank you.
Wait, just 1 second.
Great, thank you. And this actually follows on from the last question. So part of this is informational. I wonder what set of mergers your proposal will affect, because there already is a presumption for horizontal mergers that increase concentration substantially. We already shift the burden of proof. There would be other mergers where there's not any antitrust question. So then the residual mergers would be there's some antitrust question, but it's not what we call the Philadelphia the national bank set. That's horizontal, increases concentration, and you shift the burden of proof. So I assume in the set that you would be looking at, the defendants can always come forward and say it's not anti-competitive, and they can win if they can prove it. And for those where you do shift the burden of proof, here I want to bring in the last question. Efficiencies are usually not a defense. Efficiencies are taken into account in thinking about what is anti-competitive. But if the merger is anti-competitive, and let's say price raising to make it clearer, it is not a defense or an offset that the merger is efficient. So right now we have a pretty narrow area where defendants have an opportunity to prove efficiencies, and in the United States it's really narrow because it's really the area where they're proving that because of efficiencies the merger is not anti-competitive. It's not like Canada and some jurisdictions where the merger can be anti-competitive and the firms can come in with an efficiency defense. So I would be very concerned if I think your last answer was you might want to expand the purview for efficiencies in thinking about what's contractable. Was that clear or not? Was that?
Yeah, I think it was. It was clear, but yes, let me think about the writer. Well, you're saying that, I guess my sense was that people, although
two things. I was saying, how much does this change?
Yes, how much
Anything.
does it change? Well, to the extent that right now people are not looking at efficiencies at all in the US, which is that what you're saying?
Well,
Then,
except for a few except for a few hospital mergers where courts have allowed the efficiencies to come in. They're hearing, they're listening to all the claims of efficiencies, but they're listening to them in terms of, will this make the firm more competitive? Will it make consumers better off? It's not listening to it in terms of, oh yeah, we know prices are going to go up, but it's an offset.
Okay, but suppose the efficiency defense, suppose they're saying, we're going to have such great efficiencies that prices will come down.
Then the merger is usually not anti-competitive. It's
No,
very, very rare.
But I would think that argument, instead, then the authorities should come back and say, well, why can't you get those efficiencies some other way, by contract? And then we wouldn't be worried about, the increased market power you would have. So it would be a win-win.
So actually, to the extent that efficiencies are provable, it has to be efficiencies that could not be achieved in any other way, which would include by contract.
Well, if that's the status quo, then I didn't need to give the talk. But I get the which is quite possible. But I got the impression that at least somebody in this decision-making process, it could be the FTC or the Justice Department, I don't know. Maybe it's not the courts, but somebody is thinking about efficiencies and maybe deciding whether to bring a case based on that. And I think if that's true, then what I'm saying is still relevant.
Right. So it's absolutely relevant, even though it sort of comes in background in the conversation, but it focuses on contracts it really puts much more on a pedestal that there were no cognizable efficiencies because contract would have done it.
Yes. I mean, let me just put it this way. I think, in a way, I was saying I'm sort of attacking my earlier work and that of other people, because I've been working on this for decades, and I assumed all along, of course there must be benefits of integration and costs of integration. So because we see firms merging, we see firms demerging, something important must be going on there. But I guess, having thought a lot more about what can be achieved by contract, I guess my current view would be maybe it's 6 of one and half a dozen of the other. Yes, we see people doing it. Some people do it this way, they do it through a merger, some people do it by a contract. It's not clear that there's really a huge difference between those. So that's just a change in thinking. If you accept that, I think you probably will think about some of these antitrust issues a little differently.
There was one last question there that has been waiting for a long time. This is really the last, and hopefully short.
I can give it real short, and this is wonderful. I'm struck at how much of the analysis relies on assumptions or characterizations of the behavior of individuals. And I'm thinking in particular your exchange with Carl. Are you resisting the opportunism assumption that is embedded in so much of Williamson's work? And I guess relatedly, we in law school, should we not be telling our students to always look out for their clients in a very risk-adverse way?
Well, it's not that I don't think there's opportunism, but the question is, can we do something about it? So opportunism doesn't disappear if my company acquires your company. I'm not saying it stays exactly the same, but now you're a worker. You were an independent firm I had a contract with. I could be opportunistic to you before. Now you're a worker. You're the manager of the division. I can be opportunistic again to you now in a different way. You can be opportunistic to me. I think the challenge is, can we mitigate opportunism? I've suggested these guiding principles as a way to do it. There may be other ways to do it, but I think that may be the thing to think about as opposed to integration as being a sort of solution.
Okay, on this magic board, thank you very much, Oliver.